Hi, this is Eric Kirkpatrick from Kirkpatrick Law Offices in Belleville, Illinois. What I want to talk to you about today is something called a deposition. A deposition is something that if you're injured in an automobile accident or you're involved in causing an automobile accident, ultimately one of the lawyers is going to take your deposition. So what I thought I would discuss today is what I tell my clients about depositions and how to respond and what to expect. First of all, there's two types of depositions. The first type of a deposition in a civil case is called a discovery deposition. And this is when the lawyers from each side have the opportunity to discover facts about the other person's case. I represent plaintiffs, which means I represent people that are injured. I don't represent insurance companies, so when I'm taking a deposition of someone, I am deposing generally the person who caused the accident or caused the injury. But discovery depositions, as I said, are where one party gets to discover things about the other side's case. When they're taking my client's deposition, I know that certain questions are going to be asked by the other lawyer. So I'm going to use an example as a deposition in an automobile accident. If one of my clients is hurt and I'm alleging damages, I can be sure to know that the other lawyer is going to be asking my client about the accident, what happened. They're going to be asking what their injuries are, what kind of problems they've had from their injuries. They're going to be asking about prior medical conditions that the person has had, perhaps those that are similar to what they suffered in the automobile accident. They're also going to be asking questions about, what the doctors have told them, what doctors they've been to, and just in general how they're getting along with their injuries, presumably after they've been released from the doctor, which is most of the time when depositions are taken. How do we answer those questions? Well, first of all, the number one rule is always tell the truth. I always tell my clients, make sure you are absolutely telling the truth. The reason being is that this deposition is sworn testimony. There will be a court reporter at your deposition, and she will be taking down everything that you say. If you testify to one thing in your discovery deposition and your case goes to jury trial and you're asked that same question again by the other lawyer, you can bet that that other lawyer knows exactly how you answered that question in your discovery deposition. In other words, what you testified to 3, 4, 6 months or a year prior, and he's going to make it look like you're lying because you've told two inconsistent things. So always tell the truth. There's never a reason not to tell the truth, but that's what happens if you don't tell the truth. Number two is I tell my folks, I don't know is a fine answer. If you truly don't know the answer to the question, I don't know, is perfectly fine. Nobody, including the other lawyer, and certainly not your own lawyer, wants you to take a guess at something and just guess that something might be right when maybe it's really not. If you have a best estimate, that's fine. The lawyer who is asking your questions, and if you say you don't know and he wants to find out if you may know or have a best estimate, he can follow up with questions to ask you to determine what knowledge you have. It's not, if you truly don't know, you just say, I don't know, and leave it up to the other lawyer. That's what I tell my clients. Another thing that I tell my clients, if you do know, answer. So that's the other side of the coin. If you do know the answer, answer it. Don't just say, I don't know, because you're frustrated with the other lawyer who's asking you questions. I have had that happen before. So if you know, you answer. Along these same lines, though, what you want to do is answer the question that is asked of you. This is this lawyer's opportunity to discover things, but it doesn't mean that you have to volunteer anything that he hasn't asked you. In other words, as somebody put it one time, if I ask you what time it is, don't tell me how to build a clock. If I ask you what color pants you're wearing today, don't tell me I'm wearing blue pants, a checkered shirt, black socks, and a tie, because I didn't ask you all that. Listen to the question. That's the number one thing too, so that you can answer accurately and completely. You want to make sure that if it's a yes or no question, you answer out loud yes or no, not those gestures that we all use in conversation, because your intent is to make a clear record. The other thing about answering questions in general is I always make sure my clients understand, don't talk over the other lawyer. Let him finish with his question before you answer. Even think in terms of giving yourself a 1 or 2 second pause before you tell the other lawyer what the answer to the question is. Something that I find people end up doing in depositions, fortunately it's not very often, is they get mad. You can't get mad. You just have to understand that this lawyer's doing a job. You don't want to fall victim to him trying to get you mad and making you look like a bad person. As I said before, one of the things about these discovery depositions is that this is the other lawyer's opportunity to discover things, but also it's their one and only opportunity to size you up, to figure out if you're a credible person, how you're going to answer questions, how you're going to appeal to a jury. And I guarantee you that that other lawyer who reports to an insurance company is going to say back to his people, he's going to give his opinion on what kind of person you appear to be and whether he thinks you're credible, whether he thinks a jury believes you're credible. So you have to keep that in mind. Again, that goes back to the number one rule, which is be honest and you won't run into some of those problems. Along those lines, don't be surprised if the other lawyer asks who your relatives are, perhaps in the county where the accident occurred. The reason he's asking that is primarily because he doesn't want a second cousin or ex-wife or nephew on a jury. That's the only reason he asks that. A lot of people get offended at that, but don't. He just doesn't want your relatives on a jury. I need to let you know who is going to be present at the deposition. First of all, as I said, a court reporter will be there. Second of all, the other lawyer who's asking you questions will be there, but if there's any doubt, your lawyer will be there with you too. And your lawyer will be able to object if he thinks he can't understand the question or that you might not understand the question. He's there to object if it's an improper question. He is your guardian, so to speak, to take care of you during your deposition, but the other lawyer gets a pretty wide latitude. Your lawyer, however, will limit it where it needs to be limited. So number one, two is you need to listen to what your lawyer says. If your lawyer objects, you wait before that question is answered. You let your lawyer speak if he needs to. Depositions are like going to the dentist. Nobody really wants to have to do them, but by the time it's all said and done, they're not so bad. I haven't ever had anybody tell me it was the worst experience of their life yet. And they're pretty simple. They usually last, in a civil case here in Southern Illinois, maybe an hour, hour and a half. They're allowed to go 3 hours in a state court case, but longer in federal court cases. Most that I've had run anywhere from an hour to 2. So most of you that are watching this video probably already have a lawyer. However, if you don't and need legal advice on any of this kind of thing, feel free to contact my office, 618-239-6070. Thank you.